Very good. I think we have both attorneys for the next case. For the record, it's Rolando Torres. How do you pronounce the name?
Torresillas, I believe, Your Honor.
Torresia versus Citizens Property Insurance. And for the record, we have Ms. Erin Berger here on behalf of the appellant and Ms. Michelle DeVero on behalf of the appellee. All right, Ms. Berger, you've got 20 minutes, as you know, and how much time do you wish for rebuttal?
Your Honor, I'd appreciate 5 minutes.
Very good, ma'am. You may proceed.
Thank you, Your Honor. May it please the court, my name is Erin Berger, and I represent Mr. and Mrs. Torresillas in this property insurance dispute with Citizens Property Insurance Corporation. Appellants appeal the entry of final judgment in favor of Citizens. Citizens filed an amended motion for summary judgment on 2 bases, that the parties did not sit for an examination under oath, and I'll probably refer to an examination under oath as an EUO as we go throughout this argument, and I didn't want to confuse you when I make that abbreviation, Your Honors, and that they were entitled to judgment because they obtained a final judgment in another case. They believe that they were entitled to res judicata. These are the only 2 issues that were raised in their motion. The trial court entered an order granting their motion for summary judgment by simply stating for reasons stated in the motion for summary judgment. Because both Citizens and the trial court misapplied the doctrine of res judicata and genuine issues of material fact remain as to what the parties' compliance with the terms of the policy, appellants request a reversal and remand for further proceedings.
And if I may, Ms. Berger, let me ask you a question. Does your client dispute the fact that he did not show up to these EUOs?
No. In fact, there's an affidavit filed that says that he did not show up for the EUO that was requested in May. There's no additional information about any other EUOs requested, Your Honor, but that is part of the failing in terms of the sufficiency of the evidence here presented by the insurance company that we challenged in our first issue on appeal. In the first issue on appeal, we argued that the insurance company failed to meet their burden under Rule 1.510C to present sufficient evidence in support of their claim. The only information that was presented in support of their amended motion for summary judgment was certificates of non-appearance for these EUOs, an unauthenticated denial letter, and a copy of, excuse me, the insurance policy. When they filed the amended motion, excuse me, Your Honors, they did file a copy of an uncertified order from the trial court from a different judge. And on that basis, they requested judgment on the basis of res judicata. The initial brief includes many well-settled cases and authorities that identify the failing here, that any unauthenticated documents are insufficient to support the entry of final judgment. I think in their answer brief, the insurance company sort of misconstrues the argument regarding the certificates of non-appearance. We're not necessarily challenging them as unauthenticated, but insufficient here to support the claim. There's no evidence that these EUOs were requested. Contrary to what's stated multiple times throughout the answer brief, there's no evidence that these were mutually coordinated or scheduled. In fact, in the trial court, trial counsel for the insurance company did not even argue that these were mutually coordinated or scheduled. And the information that's relied upon to make that claim in the answer brief doesn't support that proposition. Other than the homeowner's affidavit, again, there's nothing to suggest that these EUOs were even requested, that they were not unilaterally scheduled, that there wasn't some reason given by the homeowner that they did not appear for them.
So I can make sure I understand your argument, Ms. Berger. I don't believe you dispute the fact that there's an obligation on behalf of your client to submit to these examinations. You agree with me on that based on the policy?
Depending on the circumstances, Your Honor, yes.
All right. And in this case, I think you're taking the position that even though the insurance company made that request, I think your issues, I hear you, that you take issue with the propriety and the manner in which they made that request. Is that what I'm hearing you?
Yes, Your Honor, and under the circumstances, whether or not that was reasonable and whether or not it was a material breach, as the insurance company claims. And if it wasn't a material breach, then they aren't entitled to summary judgment. And if it is a material breach, then the trial court erred in not considering whether or not they were prejudiced, which...
So going back, so when that request was made by the insurance company asking your client to submit to that examination, was there an objection made at that time, or was there anything telling the insurance company that we take issue with that. You're not entitled to take our client's deposition statement, anything like that at that time?
In the affidavit presented by the homeowners below, there is some indication that there was correspondence to the effect that at this point, it's been over 6 months. You have all the information you need. What would be the point, kind of, I think is the argument. And that goes back to, we need to talk about the time frame. The claim was in September.
And not to put words in your mouth, as I understand it, the issue that you're raising before us is the propriety of the insurance company to make that request of your client at the time in which they have. Is that correct?
At the time in which they did, and under the circumstances, because here we have a claim that was made in November of 2015. There was an inspection within days a couple of weeks of the report of the claim. There was another inspection within 2 months. Although it's unauthenticated in the record, there appears to be some sort of report by their inspector or expert. I don't know if they designated him, but that was dated in February of 2016. The record also demonstrates that there's nothing essentially that was done for a good period of time until the trial counsel for the homeowners requested an update about the decision, or requested a decision be made, because we're now way past the time under the statute and the terms of the policy that they have to make a decision. And they've given no, under the statute and the terms of the policy here, there's sort of an exception that says, unless there's something preventing us from doing so that you've done, and they haven't identified anything that the homeowners did that prevented them in that time frame from making a decision. And again, we're talking sort of about the totality of the circumstances here. This is the only policy provision that they say that they argue was not complied with, or that they move for summary judgment on. They did not make any request for an EUO until more than 6 months after the claim was submitted. So at this point, it sort of appears that they're doing it in effort to, sort of save face or save their claim, or to come up with some basis to deny the claim, and sort of trap.
Why couldn't they have just denied the claim based on the report that said, there's no leak in the bathroom? I know that was what the inspection report said. So if they had just wanted to deny the claim, they could have said, here's our inspector's report. There's no indication that the water's coming from any leak in the bathroom. Boom, your claim is denied. So what's your basis for suggesting they were looking for some pretense to deny it?
To come up with another way to, exclude my client's rights under the policy. They recognized that they had failed to make a determination within the policy and statutory timeframe, that 90 days from the report of the claim, and they had the information around. And that's sort of what we're claiming here is that there's not a material breach and there's no prejudice with regard to this EUO request and them not sitting for an EUO. They had all the information that they needed in February of 2016 to deny the claim, if that's what they were going to do, but didn't do that. And then they started demanding these EUOs, again, which there's not any record evidence that they actually requested these. There's just certificates of non-appearance, which only suggest that maybe they set them and didn't actually request them.
Except for your client's affidavits.
With regard to one of them, with regard to the one scheduled in June, but not the other two. There's no reference to the other two in the affidavit. So again, we're talking about whether or not there was a material breach to entitle them to summary judgment on this basis. And if there is a material breach, whether or not they were prejudiced. And we would argue that it's not a material breach because, again, they had the information in order to deny the claim if they did on the basis of whether or not the claim was covered, period. So the basis for a summary judgment that they obtained on the EUO or the compliance with this policy provision, we believe there's a question of fact remaining based on the totality of the circumstances. The insurance company argues that there's no requirement that the trial court initiate or take into consideration whether or not the insurance company was prejudiced. And to that extent, they cite the Goldman versus State Farm case, which is a case that's more than 15 years old, or about 15 years old, excuse me. And they overlook the exceptions that have been identified in subsequent case law to this line of cases that suggest that if there is some element of compliance or some partial compliance, that they, let me find the so I don't misrepresent it, Your Honor. The trial courts are required to analyze whether an insurer was prejudiced by an insured's failure to comply, and whether or not they forfeited coverage by that breach. There's several recent cases that have been cited for this proposition, including this court's case cited in the briefs, Curtis versus Tower Hill Prime Insurance Company. There's two very recent cases in the last month within the last month out of the 3rd District Court, American Integrity versus Estrada, which was cited in the answer brief, and one that was not, it just was, excuse me, that one was from August. Naveen versus Universal Property and Casualty Insurance Company. And both of these state that the trial court is required to analyze whether the insurer was prejudiced by the insured's failure to comply prior to determining that the insured forfeited coverage under the brief or under coverage by their breach. So even if the prejudice inquiry is not pertinent, or these cases don't specifically cite prejudice, the same analysis applies to the question of whether there has been a material breach. And in the 5th District Court case, Allstate Florida Insurance Company versus Farmer, a material breach is defined as something causing prejudice. So prejudice is definitely an element of the analysis here that the trial court did not consider. There's also a couple arguments made in terms of whether or not res judicata applied here and whether or not it was properly raised as an affirmative defense. There was no affirmative defense stating res judicata. There was no motion to amend after they obtained their supposedly applicable final judgment in the companion case. There's no request made to take judicial notice of the other case, although in the answer brief, the insurance company claims that that's a way that they would be able to raise res judicata. The cases that they cite are inapposite or distinguishable. There's two cases from this court, the Lagarde versus Outdoor Resorts of America, Inc. case and the City of Clearwater versus U.S. Steel Corp case. Both cases make it pretty clear that if you want to have records from another court or another case made part of the record or taken notice of by a court, you have to request judicial notice under the Florida statutes 90.902 and 90.203. In order to do that, a request has to be made and sufficient information has to be, and notice has to be given, and sufficient information has to be supplied to the court in order for them to take judicial notice. The document that was presented in support of the res judicata claim was not a self-authenticating document under 90.902, excuse me, 90.9024. An official public record must be certified, and there's a couple cases. I cited one in my reply brief that hold that is the case. You cannot just present a document to the court without requesting judicial notice from another court case. Judicial notice is not mandatory unless the party requesting it supplies the court with sufficient information to take judicial notice and gives requisite notice to the adverse parties. Here, there's no indication that the insurance company requested judicial notice or that the trial court took judicial notice. There's nothing in the orders to suggest that they did. And even if the court was able to and did, and we just don't know from the record, res judicata doesn't even apply. The companion case, as we call it, was an entirely different claim. The response to the motion for summary judgment indicates that it was a claim based on an entirely different issue. One was a kitchen claim, one was a bathroom leak. One was in September, one was in October. So we're not even talking about the same cause of action. So to the extent that the trial court granted summary judgment on the basis that res judicata applies from this companion case and a different claim that was filed against the insurance company by my clients, it's just incorrect, and the summary judgment should be reversed.
And actually, Ms. Berger, you're at a good time. If you'd like to save your remaining 5 minutes for rebuttal, or feel free to go forward if you wish. Do you want to reserve the rest?
Thank you, Your Honor.
Very good. Thank you, ma'am. All right. And Ms. DeVero, can I have you proceed, ma'am? Excellent. You unmuted your mic. You're ready to go.
Ready to go, Your Honor. Good morning, and may I please the court. My name is Michelle DeVerio, and I am appellate counsel for Citizens Property Insurance Corporation. I would like to address it seems like two of the major issues raised in order. We'll assess first the prejudice. And if this court will indulge me in order to really understand, because the second DCA has not, this issue seems to be unique in regards to the case law, but it's been very well defined in the fourth and in the third. Every appellate district in Florida agrees on two facts. One is that an EUO is a condition precedent under insurance policy. And two, that a breach of that EUO provision is a willful and material breach as a matter of law. And that's been consistent throughout the districts. Now, where the districts differ a bit is when it comes to whether or not there is a rebuttable presumption of prejudice. And it's not who needs to prove prejudice, because by the briefs and by the plaintiff's motions for summary judgment, what you see is that they're putting the burden on the insurance company and saying the insurance company needed to prove prejudice. And that's just not the law. That is a case that they're citing is Curran. And in Curran, it's a case about a compulsory medical examination, an Uninsured Motorist Act, and how it interplayed with an auto policy. Curran has been refused to be followed by the fourth DCA, by the third DCA, and by the second DCA. So currently, because the issue certified in Curran was very specific as to this CME provision under this specific kind of policy, no district has actually gone ahead and adopted it in a first party property context. So what we really have to look for is whether you have going to follow the third or the fourth. The fourth has the longest standing case law on this issue, which is the Goldman provision, the Goldman case. In Goldman, it's probably the most factually accurate case to the case at bar, in the sense that in Goldman, it was a homeowner's property policy. It was the insurance company requesting an EUO. There was complete and total failure to attend that EUO by the homeowners. And as this court properly pointed out, in this case, there's no issue of fact that they did not attend, not only in their affidavit, but the certificates of non-appearance also show the same. Then there's also, in the Goldman case, there was summary judgment in favor of State Farm. It went up on appeal. And if I may quote, the Goldman court was very specific, saying that a finding of prejudice is not essential to a resolution of legal issues in this case. The insured's refusal to comply with a demand for an examination under oath is a willful material breach of an insurance contract, which precluded the insured from recovery under the policy. And it goes to cite a Putnow case, which is from 1906. So you're talking over 100 years of law from the fourth that is absolutely consistent. After that, there is a case that comes from the second, and it's Amica Mutual Insurance versus Drummond. In that case, it's also an EUO provision. The reason that the plaintiff in that case did not attend the EUO was because of their interpretation of the policy, which is something here that is cited in plaintiff's affidavit. They felt they didn't attend, they need not need to attend the EUO because they believed an insurance company requesting an EUO on all claims is unreasonable, which, as Your Honor also pointed out, that none of that came out in the adjustment of the claim. All of that was brought out in this affidavit way after the case was denied. So in the Amica Mutual Insurance case, there the second DCA agrees with Goldman standard and goes ahead and adopts the fourth. After that comes the third with Estrada. In Estrada, essentially what the court did was mixed your condition precedents, which is your EUOs, and then you have your cooperation clauses, which is your notice provision. And essentially what the court in Estrada did is create a test and blended both a little bit. So the Estrada court tells you, in order, there's a three-part test. One, you need to see whether the insurance company pled that it was a material breach, which we did. If that's the case, then there's an automatic presumption of prejudice in favor of the insurance company. After that, the burden shifts, and it's up to the plaintiff to prove that, to overcome this with this presumption of prejudice and prove that the insurance company was in fact not prejudiced. So it's essentially plaintiff's burden if you're following the third. After the Estrada decision comes Rodriguez versus Avatar, which is actually also a Strems law case, also with issues regarding an EUO. In that case, it's from 2020. And the majority of that decision spends time on your cooperation clause because the claim was reported very late. In this case, the claim was reported several months. Both claims were reported what we would consider late, but that's not the issue here. The importance of that decision is that at the very end, there is in fact a quote from the second DCA where it says that essentially that in order to find whether condition precedent has been breached, and it's talking about the EUO and labels it as a condition precedent, you need to determine whether or not it's material, and it cites to Estrada. Now, it doesn't rely on those two other prongs of Estrada. It only is requesting the first prong, which leads us to think that the second DCA would follow Goldman. But no matter which avenue this DCA goes with, it's still all the same result. You still have non-disputed, they did not attend. That non-disputed lack of attendance is an automatic, as a matter of law, willful and material breach of the policy. If we go down to, and that's under Goldman, the analysis is done. If we go down the Estrada route and go down the second prong of the analysis, then we got to see whether the plaintiff actually overcame the presumption of prejudice in their motion for summary judgment, in their opposition to the motion for summary judgment. And in their opposition for the motion for summary judgment, the appellant, although they actually cite the wrong case, they're still relying on Coran, saying it's the insurance company. The tipsy coachman doctrine allows the wrong reasoning, but the correct result, which is exactly what happened here. They do have a one line that says, defendant cannot have been substantially prejudiced by plaintiff's refusal to sit for an EUO, given it was able to reach a covered denial based on an engineer's report. That is their one sentence, an attempt to rebut and overcome the presumption of prejudice. That is not enough. In Coral Towers, it's a third DCA case, it's a citizen's property insurance case. The court says, although it's generally reserved for a tier of fact, it's appropriately raised on summary judgment whether or not there was an overcoming of a presumption of prejudice. In that case, the appellate court said that the record failed to show any evidence or issue of fact presented by the plaintiff to overcome the presumption of prejudice resulting from its late notice. The closest Coral Towers comes to a conclusory statement by one of its engineers that there is no prejudice, and that is not legally sufficient to overcome. The second DCA is of the same opinion in the Waterwax Allstate Insurance Company. And in that case, it's very specific to what we have here. They say if the appellant had merely denied that Allstate was prejudiced, the presumption would not have been overcome and Allstate would have been entitled to summary judgment. And that's what they did here. They merely denied and said that that the insurance company was not prejudiced, and that's not enough. The third DCA, and also Hope versus Citizens has also addressed the issue of overcoming the presumption and prejudice. And in this case, on de novo review, the review of the record shows that there's not enough evidence sufficient to rebut the presumption of prejudice. In that case, there is a homeowner's affidavit, a roofer's estimate, a public adjuster's report, and the court said this evidence is merely conclusory and fails to rebut the presumption of prejudice against citizens. So whether this court chooses to go under Estrada or Goldman, the result is the same. The trial court did not err in granting defendant's summary judgment as a matter of law. Now, to address the issue of res judicata, because it seems to have been a lot of time to spend on this issue, and essentially, if there is a case law, and I will cite it now. It's Coral Ridge Properties versus Playa del Mar, and it says that, I quote, and this is a Supreme Court of Florida case. I agree that defendant is not precluded from obtaining a summary judgment on an affirmative defense not yet raised by an answer. What is find interesting, and it's something that's failed to mention in the briefs, is that plaintiffs themselves filed a notice of related cases with the court. So what really happened is when they went and made a claim, they didn't just make a claim for one loss. They made a claim for 2 losses, and 2 losses were simultaneously adjusted. There was 2 EUOs that were requested on each claim. None of them were attended to. Same facts, same property, same parties, same counsels. So when they both filed suit without attending the EUO or given reason why they were not attending the EUO, once suit gets filed, plaintiffs themselves notify this court of the related case. And in there, they tell the court, we have this case number against this judge, and these are the parties involved. So it's plaintiffs themselves that actually put the court on notice, and that's okay. And that is what the law allows. You can bring up, in lieu of a defense of res judicata, you can bring up a judicial notice of the record below from another court. And if I may quote, in the Lagarde case, which is the same case that plaintiffs rely on, that court took consideration of its own records and ruled consistently in both motions to dismiss when the issue was not raised as in res judicata. And the court said, despite the technical procedure deficiencies in the matter in which the issue of res judicata was raised below, they still granted the motions to dismiss. This notion dates back to 1970 in the Aloe Cream Lab case, where the district court says, the district court clearly had the right to take notice of its own files, records, and it had no duty to grind the same court for the second time. Once was sufficient. So essentially, if any error was had, it is harmless error. The only error was that plaintiff did not write the word judicial notice of related cases when they notified the court. But in their motion for summary judgment, they also go into the facts of this companion case. They brought it at issue when they start to discuss what had happened and what occurred in the companion case. So the court did not err, because if you really think about res judicata and the defense, the point of it is to avoid an ambush, to avoid prejudice, and to avoid inconsistent opinions. And that's exactly what occurred here. They put us on notice. We knew about the parties. Nobody was prejudiced. It was their own case, so nobody was ambushed. And the rulings were consistent. So you didn't have the same lower court making inconsistent rulings on essentially what is very similar, if not exact, to the claim. I would like to address appellant's case law that they're relying on, stating that they rely on the Himmel, Heyman, Solano, Nawaz, and Louise case for the proposition that the plaintiff somewhat complied with the EUO provision, and therefore a materiality needs to be taken into consideration. What's interesting is that all those cases come from the Fourth, yet they want to stay away from Goldman, that also comes from the Fourth, but then they're citing Goldman's progeny, which is all case law from the Fourth. Every single one of those cases has the same common element, the element of some compliance with the EUO. In those cases, either they attended the EUO and there was an issue as to which party can attend, There was an issue as to the scheduling of the EUO, where there's record evidence showing that the plaintiff was actually trying to reschedule. There was just some compliance. So when you have some compliance, the court says, okay, then there may be a question of fact as to whether you substantially complied in order to see whether you materially breached. But when you have a total failure to attend an EUO and a total failure of a record showing any type of compliance, then you're back to Goldman, which is a willful material breach of the policy. And if that's the case, there is no prejudice that needs to be done. Goldman goes actually as far as to cite case law all over the US, where they say that a condition precedent under a policy, there should be no finding of prejudice in order to determine whether or not that condition was met. So in order for the appellant to now attempt to rely on the fourth to say, yeah, we substantially complied, so it's a question of fact, is just incorrect. There's also been an argument regarding our evidence and the admissibility of it regarding its authentication. A review of the motions for summary judgment will show that that argument was never raised below. There was never any argument or any objection made to any of the evidence submitted on behalf of the defendant. So as your honors are well aware, if it wasn't raised in the record below, it is waived now. So any argument where in res judicata we were not able to bring the certificates of non-appearance because of authentication, it's not an authenticating document, all that is waived, and it's not up for issue here. I would like to bring up one more case if I have time.
You just have a couple of minutes left, Ms. DeVere.
Okay, great. There is a case that they rely on heavily as well. It's Lane versus Allstate, which is a Northern District case from 2005, because there is an element of reasonableness that they're trying to insert into the policy and timeliness. The policy by no means does it require a claim to be adjusted within a particular amount of time. There's just no policy requirement that requires that. Florida statute has some mention as to, unless there's something outside of our control, like two claims being filed simultaneously, then you need to do it within 90 days, but this is Citizens. Citizens is a government entity and is statutorily immune to any of those bad faith statutes that are being referenced in appellant's brief. Now, the case that they do decide in order to say, well, it wasn't reasonable. We didn't have to attend because it wasn't reasonable request. Again, that would be this court rewriting the contract, because in the contract does not say that our request needs to be reasonable by plaintiff standards. We say that as often as we reasonably require, which is just as many times as we would like, but it doesn't say we need to make a reasonable request. In the case, the Lane versus Allstate case, it's a case where there is actually a criminal action going along with the same first party property action. And in that case, the appellant did not want to attend because they did not want to incriminate themselves. And in that, the court even then said it doesn't matter. At the very least, he failed to establish lack of prejudice and thus could not prevail on the most favorable view of the law that he can reasonably advocate. So it's not, reasonableness just has nothing to do with the issue of whether or not they failed to attend the EUO. And as Your Honor correctly pointed out, there's zero issue of fact showing that they failed to attend for some other manner that was just not a willful unattendance of the EUO. And for these reasons, we believe that a remand is improper. A remand would be futile at this point because the court went through the prejudice analysis when there was a total failure to attend. And res judicata does not need to be raised as an affirmative defense. It could be a judicial notice with plaintiffs themselves notice the case when they filed their plaintiff's notice of related case on both companion cases. So a remand essentially like we said, it would just be futile at this point. And we
And
believe
if I may, Ms. Rivera, you're getting closer to the very end. All right.
okay. Thank you, Your Honor.
Thank you, ma'am. And if I could have you mute your microphone, and then Ms. Berger, you have your rebuttal time, ma'am.
Thank you, Your Honor. I'll just start with the preservation issue. There's, the court has de novo review here. The court has the ability to look at the total record and identify any failings, which there are many, by the insurance company to satisfy its burden on its motion for summary judgment and under Rule 1.510. Also, there's precedent in this court for the court doing that without the issue being raised, and that precedent is West Edge 2 versus Kunderas. It's a case from 2005, which this court relied upon, and it's Rodriguez versus Avatar case from earlier this year. So it doesn't necessarily have to be specifically raised. The court is able to find an insufficiency of summary judgment evidence as a matter of law under de novo review, even if it's not specifically raised in the trial court. And I'm unfortunately having to spend a lot of time here now addressing cases that were filed in a notice of supplemental authority at 5:08 p.m. yesterday under Rule 9.225. And I would suggest maybe the notice be stricken because of the lateness of the filing, because many of the cases could have been and should have been discovered prior to the filing of the answer brief here. All of them predate the filing of the answer brief. But just to address some of the issues to the extent that I was able to review them last night after receiving the notice of supplemental authority. The Rodriguez case, in terms of showing prejudice and excuse me, I'm gonna have to come back to that, but the cases, the Coral Ridge case is distinguishable because there was no answer filed prior to filing the motion in that case. Here we have an answer. The insurance company made no attempt to file any sort of motion to amend to add the defense. The Coral Ridge case is similar to the City of Clearwater case in that there's no issue of whether or not the defense was waived because it was pre any answer, both issues. The Hope and 1500 Coral Towers case involve the condition of giving prompt notice to the insurance company. Both of these cases are distinguishable because that particular condition under the policy, the case law, even from this court in American Fire and Casualty versus Calora, 163 Southern 2nd, 784, distinguishes that from other policy provisions that are conditions precedent in that does carry a presumption of prejudice, whereas other material breaches require some showing of prejudice. And they distinguish the notice claim from other, or the notice provision from other provisions and conditions precedent. The Weatherwax versus Allstate case, this apparently has been cited or presented to the court to offer an argument that wasn't raised in the answer brief, and that's all that my notes say. So I'm sorry, I can't address it again. I haven't had a sufficient opportunity to address it. But also the Hope and the 1500 Coral Towers case, there's no argument in the answer brief that the homeowners did not rebut the presumption of prejudice, or that there was even a presumption of prejudice to be applied here. So again, we're talking about supplementing a brief here inappropriately. With regard to our reliance on the Curran opinion, and the issue is not so much that it specifically applies because it is a motorist case and it is a medical examination case, but the same logic applies. They're talking about conditions precedent and subsequent to a policy and the policy's effectiveness. Essentially, we're talking about a condition subsequent here in that case, but it's also condition precedent to the filing of a lawsuit, which under many contexts requires a demonstration of prejudice. And here, the homeowners did demonstrate that there's no prejudice. We demonstrated, and as insurance company admits, they were able to make a coverage determination, but they've concocted a way now to also try to get the homeowners to forfeit their rights under the policy by setting them up for failure 6 months after they reported this claim, by demanding EUOs that they didn't even need. There's no suggestion of why they needed to take these EUOs or what would have changed had they been able to take these EUOs. There's no record evidence here to support the entry of summary judgment. They failed to present sufficient evidence. They've failed to offer anything that the court could take judicial notice of from another case that's not even a prior final judgment, not even the same facts, two totally different causes of action. So res judicata does not apply.
And Ms. Berger, with that, ma'am, you just came up at the end of your rebuttal.
Thank you.
Thank you both so much. I appreciate it. And if I could have you now sign off, and then we're ready to call the next case. Thank you both.
Your honors.